Well, hello again, everybody. Estate planning attorney Paul Rabelais here. Got a lot to share. It seems like, boy, I just keep thinking of topics. We keep getting questions, and the material never ends. So happy to share you this live stream. Give your children some of their inheritance during your lifetime. So got a lot to share here. We'll go through just the does it make sense? What are the tax rules? What are other rules that might apply? Um, and so, yeah, lot going on there. So already seeing some chat. Dan, Larry, Susie, May. See some questions there. Hope to get to all of them. Love the chat. Love to see you participate in the chat. Feel free. Of course, we keep it positive, but comments, experiences, questions. Feel free to throw it in there. Love it when we see some people contributing to the chat, and then we've got other people on the live stream answering questions and talking to people through the chat. So it's all about this community here. Okay, so excuse me, this topic comes up often in my estate planning practice, where we work with clients. And some people say, Paul, what do you think about maybe making some gifts or giving some money to our kids while we're alive? Some people actually go further and say, it doesn't seem to make sense that, we may live till we're 100, and it doesn't make sense that that our kids should have to wait until they're 75 years old, 70 years old, 80 years old, or whatever, before they can really benefit from what we intend to leave them. Maybe we should give them some ahead of time. So it's great when people have that ability and flexibility to be able to make those kinds of decisions. So this is all about striking a balance between risking that you'll be depleting your retirement assets versus taking care of your kids and probably the people that are most important to you during your lifetime. So I want to break this down into several different parts. And hey, Bradley, Ray. All right, we got a good crowd here for a Friday evening. Number one, why all the fuss? Number two, I want to tell you my story. Number three, talk about some gifts that people make during their lifetime, kind of pros and cons, tax versus non-tax consequences. We'll talk about what about when the first spouse dies? What do couples do there? And then we'll talk about some options that surviving spouses have after the first spouse dies. So keep saying hello. Love the hellos. Love seeing everybody, seeing the names, seeing the familiar names, seeing the new names. It's all good. All right. So why all the fuss about giving kids a sliver of their inheritance while the parents are alive? So every family is unique, but I'm sure you see what I see, that people in their 60s, 70s, and 80s, a lot of those people are savers, and they've done an excellent job saving, using, compounding growth to build an estate that is, quite frankly, more than they could ever spend. Many of our clients are very fiscally conservative. They're frugal, but nonetheless, they're excellent savers, and they've saved for 30, 40, or 50 years. And they wind up with, an estate worth many millions, sometimes tens of millions of dollars. And then on the flip side, many of those couples or individuals have children who are now in their 20s, 30s, and 40s who are struggling. Many of them are trying to save, but they're struggling because harder to buy a house these days, because the down payment requirement as house prices grow. Average house price somewhere around $400,000 or $500,000 a year to put a 20% down payment on a house. That's it could be $100,000 payment that kids in their 20s, 30s need to buy their first home. I remember it was my family's second or third home, but I think my parents bought that home in 1968, and I think they paid something like $28,000 for that home. So it's not like that anymore. So the kids of these savers, they have challenges. The mortgage rates are high. Kids either can't afford the down payment, can't afford the monthly payments. Now they've got to educate their kids and just meet all of their ordinary living expenses. It's a challenge. So what this is all about is, if parents can swing it, we're not saying all parents should start giving to their kids immediately, but if parents can swing it, and a lot of the stars have to align. If the kids will be responsible, it may make sense for the parents to start advancing some of the inheritance to that next generation. Again, that's a balancing act between depleting the assets, don't want to do that, versus helping the kids. And some parents want to do that. So it can be life changing. Let me tell you my story. I could probably tell you hundreds of client stories where parents have told me about how their parents may have done some gifting, or parents may have told me about the gifting that they do for their children. I've heard that for 30 years. And I continue to hear it on our Zoom calls that we have with our clients around the country who kind of, oh, by the way, if you want to sign up for something like that, it's all in the description. But let me just tell you my personal story, even though we've helped many clients and some of the client stories are better than my personal story. But my personal story is I was the youngest of 5 children. My parents were extremely frugal. I think they were born in 1928, 27 or 28. And when I was growing up, 60s and 70s, our family, a really special trip was a trip to McDonald's. And that was really, we were really living high on the hog when we were able to go, when my parents were able to take us to McDonald's. However, when we go to McDonald's, I'm a cheeseburger guy. And my parents wouldn't let me get a cheeseburger. I would need to buy a hamburger and then bring that hamburger home and then put a slice of cheese from the refrigerator onto the hamburger to make it a cheeseburger. That's how frugal my parents were. But God bless them. They earned, they saved. My dad was an engineer, worked for a chemical company. And lo and behold, they wound up having more money that they felt like they could spend. Like many of our clients do. Many of our clients, they watch their expenses closely, but they save. And so many of our clients, when they get to requirement and when they get to that RMD age where they have to start taking required minimum distributions from their retirement accounts, they don't need them. So nonetheless, when my parents were about 70, I was the youngest of 5. I was born when they were 38. So when they were 70, I was probably 32. That's when my parents every year would, at Christmas, would write a check for $5,000 to each of their children. They'd give it to us in a special envelope every Christmas morning. And $5,000 may sound like a lot to some people, and it may not sound like much to many people. But as my wife and I were trying to, raise 5 young children, which we were trying to do in our late 20s and early 30s, that $5,000 tax-free gift that we got on December 25th of every year, it made a difference. We were able to, take care of the next month's mortgage and other educational expenses. So that's just my story. My parents did a little of that. And I think they really enjoyed seeing the appreciation of their children when they did it. They really enjoyed kind of helping lighten the load a little bit for each of their 5 children. So that's just my story. All right. So let's just tap into this here because there's some tax stuff and there's some non-tax stuff that we want to go to. So this is about parents, might be a single parent or it might be a married couple. This is the idea of, hey, they may be in the back of their minds, they're thinking, we've done pretty well. Stock market's been good to us over the last 30 years. We have more than we need. A couple might say, we did all the financial projections, and it looks like with our Social Security and with our pension, not everybody has a pension, but many people do. With our Social Security and with our pension, we live comfortably off of that. With the retirement assets and other liquid assets that we have, that total X might be $1 million, might be $3 million, might be 10 million. Many parents say, maybe we should be helping the kids. And then the question comes up, what's the deal? What's the law? What's the taxes and all that? So let's go through that. First, let's talk about gifts that parents make during their lifetime. Let's talk about the tax angle. Love seeing the chat thing scroll up. Keep throwing stuff in the chat. Love to hear your experiences, your thoughts. In fact, by the way, I made just to run a little test. Sometimes before these YouTube live streams, I run a little, maybe a 60-second or 90-second video on another platform and threw this out there. And lo and behold, dozens of comments. Many people were kind of surprisingly to me, many people were like, yes, parents should do this. Many of the comments, we're doing this for our kids. Our parents did this for us. Yes, you want to make sure you don't deplete your retirement income, but yes, so got a lot of positive comments on the thought of of that little post on that platform of parents giving some of their children an inheritance. Unfortunately or fortunately, my 5 kids saw that post and they circled that post around on our family group text. And they were jokingly asking questions like, all right, so where do I send my account information? And this is the best post you've ever made. So, they joked about it. And I said, easy now, guys. All right. So here's the deal. So let's talk about some of the tax stuff. If you make a gift to your kids during a calendar year, one or more gifts, and that gift or those gifts during that calendar year are less than $18,000, then nobody's got to report anything. Nothing reported on an income tax return, nothing reported on a gift tax return, doesn't affect any kind of estate tax down the road. So basically the IRS says, you know what, we're going to let people give up to $18,000 to as many people as they want to every year without having to do any special reporting. So if you're a married couple, you can give, each spouse can give. So, married couples can give up to $36,000 to as many people as they want to every year. Nobody does any reporting. It's not taxable income to the recipient of the gift. It's not a deduction for the person making the gift. No 709 gift tax return needs to be filed. So that one's really easy. Now, if these gifts are in excess, if an individual makes gifts in excess of $18,000, and again, it's a calendar year thing. So if you gave someone $10,000 on January 3rd of 2024, and then what did I say? $10,000 on January 3rd, and then you give them another $7,000 on December 1st of 2024, you've made $17,000 of gifts during the calendar year. No reporting necessary. But if during the calendar year you give them, more than $18,000, then again, there's no tax consequences to the recipient. Regardless of the size of the gift, the recipient doesn't pay income tax on it, doesn't pay any tax on it. So if you give $118,000 to one of your children or to anyone for that matter, you did give more than $18,000. So the recipient, as we say in estate planning world, the donee doesn't have to report that as any kind of taxable income, doesn't owe any tax as a result of receiving a $118,000 gift. But as we say in estate planning circles, the donor, the person who made the gift, again, it doesn't affect their income taxes one bit, but they will have to file a IRS Form 709. It's called a gift tax return, showing they don't owe any gift tax, but they have to show that by making a gift of $118,000 to one person in one calendar year, the first $18,000, no problem. The other $100,000, well, that individual who made the gift used $100,000 of their, what is in 2024, $13.61 million estate tax, gift and estate tax exemption. So really what they did was, if they die later in the year, then they could only, instead of only being able to leave $13.61 million free of estate tax, they can only leave $13.51 million free of estate tax because they used $100,000 of their gift and estate tax exemption during their lifetime. So that's the only tax consequence of someone making a gift in excess of $18,000 to someone in a calendar year. Yeah, it's 18 this year. It was 17 last year. I think it was 16,000 the year before. It was $10,000 a long time ago. But just know it's adjusted for inflation, but it only goes up when the adjustments for inflation cause it to go up in increments of $1,000. So we'll see if it's $19,000 next year, or it will stay at $18,000 for 2025. All right. So, and look, that same figure applies regardless of the type of gift that it is. It could be a gift of cash. Maybe you write your child a check. You write them a check for $18,000. Or maybe you give them a piece of land. Maybe you give them a lot that you own so they can build on the lot that is now theirs. But if that lot, its fair market value of that lot when you give it to them is $100,000, then you did make a $100,000 gift to them, and you'll have to report that on a 709. Sometimes parents ask me, well, Paul, what if, I do have this lot and it's worth $100,000, but what if I sell it to my child and I sell it to them for, say, $10,000? Can we skirt around this whole gift tax reporting by selling it to them for less than what it's worth? And the answer is no. And obviously, the IRS will scrutinize these intra-family transactions more than they'll scrutinize transactions between two third parties, neither one of which knows each other. So when a parent sells the $100,000 piece of property for $10,000 to their child, really the way the tax law looks at it, they made a gift of $90,000. So got to be aware of that on these intra-family transactions, particularly when you're trying to sell assets to a child for less than what it's worth. Another aspect to consider when the gift is something other than cash is the step up in basis versus the carryover in basis rule. So if, for example, dad has that lot worth $100,000, but he only paid $20,000 for it when he bought it many years ago. If he gives that lot to his daughter, then and he gives it to them during his lifetime, then the daughter's capital gains tax basis in that lot will be a carryover basis, $20,000. So if she sells that lot in the future, her basis will be $20,000. If the daughter inherits that lot from dad when it's worth $100,000, the daughter's basis will get there will be a step up in basis. So the daughter's basis will be the value of the lot on the date that dad died, $100,000. Many people ask, does that lot have to be in dad's revocable trust, or what does dad need to do to secure that step up in basis? And it's real simple. It kind of happens automatically as long as that lot is in dad's estate for estate tax purposes. Even if dad doesn't have a taxable estate, then that secures that step up in basis. So yes, so where we're at, make gifts of up to $18,000. Nobody reports anything, regardless of what the gift is. Married couples, as long as the gift is being made jointly by both spouses, then they can give up to $36,000 to as many people as they want to every year. And quite frankly, even if only one of the spouses is making a gift of $36,000, the non-gifting spouse can file a tax return and consent to gift splitting, where it's deemed to have been made one half by each of the spouses. That's called gift splitting, when one parent is only giving their assets, but they want to use both spouses' $18,000 annual exclusion amounts. All right, so a couple of other issues that come up when parents want to help out the kids, and it's these kind of nominal amounts under $18,000, or maybe it's a significant amount. So some parents, virtually all of their liquid investments are in their IRA. We work with a lot of people. They're like, Paul, we've got our house, it's paid for, and we've got our checking account with a little bit of money in there, maybe 10,000, 15,000. We have a savings account with a few $1,000s, but we have $2 million in the IRA, and we'd like to help out our kids. So it's, they don't want to deplete their kind of cash reserves, the money in their checking and their savings. So it's kind of tough when parents want to gift to the kids, but the liquidity is all tied up typically in a traditional IRA. So, to do the gifting, the parents have to, you can't just gift a portion of an IRA, or you can't just take the money out of their IRA and give it to the kids without there being income tax consequences. So when a parent does have a traditional IRA and they want to start helping the kids out of that money, they've got to take a income taxable distribution out of their traditional IRA. In fact, that kind of works oftentimes, because we've seen a lot of parents tell me something like, Paul, we're set up pretty good with our Social Security, with our pension. Sometimes parents own a business and get some dividends. Sometimes parents own some rental property and get some rental income. Sometimes parents have a brokerage account that's outside of their retirement account, and they're getting some dividend income out of that. And all that income, more than covers the parents' needs. And then in addition to that income, once the parents reach that required beginning date where they have to start taking required minimum distributions, that's kind of an easy source of income where the parents can help the kids. Because many parents are saying, geez, I got to start taking this RMD, and they might say, well, we have this $3 million in IRAs, and the RMD, heck, it's going to be $120,000. Yes, the parents have to pay income tax on that required minimum distribution, but it's income that the parents don't need. So that's been oftentimes a good vehicle, yes, for those after-tax RMD distributions, for that after-tax money to be distributed or given to the kids. It often falls within the $18,000, or for a married couple, $36,000 from the parents to each child or to each grandchild, whatever the case may be. So that's often an easy kind of, let's help out the kids this way. Some parents like the idea of setting up Roth IRAs for their children, for their grandchildren. As long as the children and grandchildren have earned income, those children and grandchildren can set up Roth IRAs, and maybe they wouldn't be able to set aside the funds to establish and contribute to those Roth IRAs unless the parents or grandparents give the kids or grandkids money to be able to, contribute to that Roth IRA. And that's a great thing, because that Roth IRA just continues to grow and grow and grow for 30, 40, 50, 60 years. And it all comes out income tax free. So that's pretty cool. And then, you see a lot of grandparents setting up 529 plans for their grandkids. Another great deal. You can even, you can do some of the annual gifting. You can front load it and do up to 5 years of gifting and do that all in 1 year if you want to set that up. So there's just lots of different ways that parents and even grandparents now who are in their 60s and 70s and 80s are doing some things to make it easier for their kids. Now, there may be a significant estate tax benefit to doing that, because I'm going to do a live stream here coming up where you can find it on my channel. The title is something like, if you have $5 million in investments now, should you be worrying about the estate tax? And quite frankly, particularly the younger that you are, if you're 60 with $5 million of investments and you live to 90 or 95, those investments could be worth $50 million by the time that you pass away, depending upon, of course, all the investment performance stuff. But so by doing some gifting now, assuming you can financially swing it, you don't feel like you're going to be depleting all of your retirement assets, you've got more than enough to live off of, you may very well be saving a significant chunk of federal estate tax when you pass away. Let's say over the course of the next several years, you make a bunch of these gifts of $18,000 or $36,000 if you're married to your children, your grandchildren, whoever you want to. And over the course of time, maybe, you shift maybe $400,000 or $500,000 out of your estate to the next generation. Now, we don't know if your children or grandchildren, or we don't know what you'd want them to do with it. You may want them to hold on to it, invest it. You may feel like it's okay for them to spend it just to improve their way of life a little bit better. But by transferring a few $100,000 out of your estate now, and then, if whether or not it's invested, but assuming it's invested, that $400,000 or $500,000 that you get out of your estate now could grow, if it's invested, to millions of dollars before you pass away. Now, all of those millions of dollars avoid the 40% estate tax when you pass away. So you're immediately preventing that $18,000 gift from being subject to the 40% tax when you pass away. And quite frankly, if you make that gift and it's invested, then all of the future appreciation will avoid the 40% estate tax when you pass away. So now maybe you've done a couple of really cool things. You've helped out kids while they're alive because you can swing it and you watch them enjoy it. So there's a lot of non-tax reasons why you want to do that. And then on the other hand, because we don't know what the estate tax will be. I mean, you're 60 now. Who knows what our tax system will be like when we're 90? We know what it's going to be like in the next couple of years. We know that you have an estate tax exemption in 2024 of $13.61 million. We know it's going to go up next year to somewhere around $14 million. We know in 2026 it's going to be adjusted for inflation again, but then it's going to be cut in half. So it's going to be somewhere around $7.5 million. But Congress tomorrow could change all of that. And if you're 60 or so, or kind of like me, when I started working as an estate planning lawyer, the estate tax exemption was $600,000. So when someone passed away, you added everything up that they owned, and if they had more than $600,000, there was an estate tax of up to 55% on the value of everything that they owned that exceeded $600,000. Started at 37%, but went up to 55% pretty quick. So we just don't know what the estate taxes will be, a decade from now, much less 3 decades from now. So to the extent you do help out your kids by making some gifts, you're likely to be saving some significant estate tax. So a lot of pluses there. And then if you're another issue, again, we're just talking about making gifts while you're alive. And so a couple of other issues around that. One is, of course, what do you gift? Do you gift cash? And generally speaking, cash is the best kind of gift, versus giving some asset that may have appreciated in value, and your children receive that asset with a carryover in basis, which most people don't like the thought of losing out on the step up in basis. So you give away the cash assets, you let the other assets remain in your estate, and then when you pass away, all those assets get a step up in basis. Let's see. Another issue involved with helping your kids or even your grandkids is, what if you help one child more than you help others? Maybe you give one child the $200,000 piece of land because they'll never own a home unless you give them that land, and then maybe they build a small home on that land, but otherwise they'd never be able to afford a house. But you don't do the same thing for your other children. So there's an issue there, and that can create some family drama. Do you keep score of what you've given to your children during your lifetime, and set up your estate planning documents? So if you gave child A $100,000 during your lifetime, but you didn't give child B $100,000 during your lifetime, then if you're keeping score, then when you pass away, child B, who didn't get any gifts during your lifetime, gets $100,000 off the top, and then A and B split everything else that's left behind. Or do you just say, hey, look, whatever I give during my lifetime, we try to be fair, we try to be equal, but we realize different children had different needs. And yes, we realize we helped out certain children more than others, but nonetheless, our feeling is, parents often say, that whatever we did during our lifetime doesn't matter. Whatever we have left when we pass away, that will be split equally among our children, regardless of whether we did more for one of them during our lifetime. So that issue can come up, particularly if those gifts are unequal. Another issue to decide is whether those lifetime gifts should be what I call either outright or in trust. So let's just take cash. An outright gift of cash is where you write a check, for example, and you make it out to your child, and your child gets that money. That's an outright gift. They can, your child can do whatever they want to with that gift. They can spend it, they can save it, they can give it to their spouse, they can give it to their kids, no restriction, an outright gift. Well, another option is to make those gifts in trust for your kids. And then there's a decision of, and some parents do that because they want to make those, the gifts and the accumulation of any compounding, they want that to be in a trust, maybe so that if the child gets divorced, the child keeps the trust, the child and their spouse split other assets that the child and the spouse accumulated during their marriage. And so it makes those gifts somewhat divorce proof. Another reason you might make a gift in trust is maybe you want whatever is left in that trust to go on down to your child's children when your child passes away. So there's some reasons to use trust for that. Or maybe you make that gift in a trust and name someone other than your child or grandchild, whoever you're gifting the money to. You name someone other than your child as the trustee or a co-trustee with that child. There could be some kind of lawsuit protection for your children in that vein. If you're giving to children and you're concerned they're not going to be responsible with that money. You could give it to them in a trust, name someone else as the trustee. So any distribution to that child would have to be approved by some third party trustee. So lots of different options there. Some people might say, no, I want to leave it to them in a trust. And they might say, Paul, I realize it's only $18,000, but I want that to accumulate in a trust for them. And then when I die, their share of the remainder of my estate will go into that trust. So all the lifetime gifts and the death gifts would go into that trust. So there's some options there. I'll bring up the old ILIT, Irrevocable Life Insurance Trust. We don't see it nearly as much as we used to when the estate tax exemption was much lower. But nonetheless, I'll bring it up because the way it kind of used to be done, and still is in certain circumstances, is the idea of maybe in the old days, especially, let's say a parent did or some parents did a calculation and realized, boy, based on what we own with an estate tax exemption of 1 million or whatever the case was years ago, maybe a couple realized that, boy, when we die, there's going to be a $3 million estate tax liability. So what some parents would do is they would make gifts to what's called an ILIT, or Irrevocable Life Insurance Trust. And then the trustee of that trust would purchase life insurance on the parents' lives. The parents didn't own the policies. The parents didn't have any, what's called, for estate tax purposes, the parents didn't have any incidents of ownership in those policies. Those policies were owned by an irrevocable trust for the kids. Parents made gifts to the trust, typically within the annual exclusion amounts. And then the trust used those gifts to pay for the life insurance. And then when the parents died, let's say $3 million was payable to the trust could use those funds to pay the estate tax liability. And then the children would inherit all of the remaining assets in the parents' estate. So again, you don't see that as much because not nearly as many families are subject to the estate tax, but we'll probably see a little more of that as the estate tax exemption gets cut in half. So lots of options there, and lots to discuss regarding a parent or married couple parents trying to decide whether to help out the kids during the parent's lifetime. All right, now let's step it up a little bit and talk about what some of the married couples' decisions are as to what happens when the first spouse dies. This is not typical because many married couples, it is common, but not typical. Many married couples feel like financially, if one of us dies, we're not sure what that surviving spouse is going to need. So we don't want anything going directly to the children when one of us dies. We want that pot to stay intact just in case the surviving spouse needs it. The surviving spouse might live another 20, 30, 40 years. We don't know what their needs will be. So we want to make sure all of our combined assets are available for that surviving spouse. But not every married couple thinks like that. Many married couples, especially those who've saved and have assets that they pretty much know, or they just know that they're not going to need, and they know that the surviving spouse is going to need. Many married couples will say something like, when one of us dies, we want some assets to go to the children or the grandchildren, whatever your decision is. We want some assets to go to the children or the grandchildren right then. The surviving spouse is going to have plenty. They'll have the pension, they'll have the Social Security, they'll have income from other resources. So some parents will say, well, when one of us dies, let's leave $100,000, $500,000, $1 million to each of our children. And then the surviving spouse can live off of the remainder of the assets. So what are some of the consequences of that? Well, one, you want to make sure the surviving spouse is going to have enough assets to live off of. But let's say you checked that box and you know that they do. So there really is, from a tax standpoint, no limit on how much you can leave the kids or grandkids when the first spouse dies, other than the estate tax exemption limit. The state tax laws are really set up so that it's pretty easy for married couples, if they do have the large estate, pretty easy for married couples to set things up so that there is no tax when the first spouse dies. Any tax that would be due is due not until after the surviving spouse passes away. And even then, it's only due if that estate exceeds 2 times the applicable estate tax exemption because each spouse has an estate tax exemption. And for 2024, it's $13.61 million. Now, the only time there may be estate tax that's required to be paid when the first spouse dies is if the first spouse dies and left too much in a way that didn't qualify for what's called this marital deduction, which is the rule that allows estate tax to be deferred until both spouses die. So if someone does leave their children, in 2024, more than $13.61 million, or leaves non-spouse people more than $13.61 million, there's going to be estate tax due on that excess over $13.61 million. So what most married couples do, they can play around with their estate tax exemption amount, and they can leave that straight to the kids if they want to, or to the kids and the grandkids, or to anyone. But typically what married couples do is, as to that amount in excess of the estate tax exemption, it's either left to the spouse or left in, hate to use these big terms, in a Q-tip trust for the spouse, which qualifies for the marital deduction, which allows for no estate tax to be automatically due when the first spouse dies. So there's a lot of couples out there who like the idea of, hey, we don't expect the survivor of us to be influenced and leave the estate to some third party other than our kids. But for a couple of reasons, we don't want our kids to have to wait until both of us die to receive some of the inheritance. And, there is some protection for the kids if they get some assets when one of us dies. And that avoids the potential problem that we don't think will happen of the surviving spouse, doing something silly with the estate. So for a lot of reasons, sometimes married couples do arrange their estate planning so that some assets go to or for the children when the first spouse dies. A lot of similar decisions that need to be made. Do you give it to them outright? May depend on how much you're giving them and whether you're concerned about them losing it if they get divorced, them losing it to a potential lawsuit, them squandering it because they don't financially manage money well. All those factors go into whether you leave it to them outright or in a trust. All right, so there is another planning opportunity that I want you to be made aware of. It's and a lot of what I do, we deal with, I'm on these Zoom calls all day with people around the country, California, New York, Florida, Tennessee, Texas, whatever, with our national law firm, with our co-counsel that we have that participate from around the country. Works out fantastic. A lot of couples here are, they don't know what the future holds. They don't know how long they'll live. They don't know how long the surviving spouse will live. They don't know what the stock market will do over the next 30 years. And they just, a lot of uncertainty. So just keep this in the back of your head. Married couples can arrange things to, generally speaking, provide that when the first spouse dies, nothing goes to the kids directly. Things stay put for the surviving spouse. But many estate plans are set up for this opportunity, either because the estate planning documents provide it, or trust law or state law authorizes it, where once the first spouse dies and things are generally left to or for the surviving spouse, if they do it timely, which is typically within a 9-month period after the first spouse dies, a surviving spouse can say, well, wait a second here. I know I'm entitled to inherit all these assets now that my spouse has died. But you know what? I don't need all of these assets. I would like to see some of them go to the children. So we have all of this disclaimer law so that instead of the surviving spouse inheriting and receiving all of those assets and then having to gift it out slowly to the children or to the grandchildren, when the first spouse dies, as long as the stars are aligned and things are set up right, a surviving spouse can say, I'm going to, a couple might have 4 children. And a surviving spouse might say, you know what, I'm going to disclaim $1 million of assets that I'd be entitled to get the benefits from my spouse who just died. Or I'm going to disclaim $2 million of assets. and I have 4 children. And basically, what that surviving spouse is saying is, I'm entitled to this $2 million and a lot more than the $2 million. But I tell you what, I'm going to disclaim $2 million of it and let it just go straight to the 4 children. They'll each get $500,000. And so that's a way for a surviving spouse to get a chunk of assets to the children when the first spouse dies without having to inherit it and then gift it away under these minimal $18,000 annual exclusion amounts. So, and again, what will happen is the first spouse to die will use part of their $13.61 million estate tax exemption to shield the $2 million that the surviving spouse disclaimed from estate tax. And then, if there's more unused estate tax exemption that the first spouse didn't use, an estate tax return can be prepared, portability election made to tack the unused estate tax exemption of the first spouse to die to the surviving spouse's estate tax exemption. So a lot of flexibility there. And so the key is making sure it's all set up properly from the get-go. Okay, so if I were to summarize this, I'm not going to hit the chat here in a minute. We got some good stuff. So hang on for that. Yes, there's a lot of reasons why parents do some gifting to the kids. And some of it is just completely non-tax related. It's like we want to help the kids. And maybe parents are saying, we got help from our parents. We'd like to provide help to our children. And so there's some tax aspects to it. We talk about the $18,000 present interest annual exclusion. There's some non-tax aspects to it. Yeah, we're going to give them some assets, but do we want to just put it in their name, or do we want to put it in a trust for them to make it more divorce proof or creditor proof, or to keep them from squandering those gifts after we give it to them? So there's some angles there. There's some, as a married couple, do we want to provide an inheritance for our children when one of us dies so that they don't have to wait another 20 or 30 years for the surviving spouse to die? Or do we want to set things up so that the surviving spouse, if they want to, can disclaim some of the assets that they would be entitled to inherit from the first spouse's death in order, again, to get some assets to the children when the first spouse dies? So lots of decisions there. A lot of those decisions have to do with the carryover basis on gifts of appreciated assets versus the step up in basis on an inheritance of appreciated assets. So that, capital gains tax basis also often comes into play. So a lot there. We're going to keep this discussion going on our community website. It's called the Impactful Inheritance Community. Takes this community to another level with a platform that's going to help us build deeper relationships, form meaningful groups. And I'll go live once a week in that community as well. Feel free to check it out with a 30-day free trial. The link is in the description. Impactful Inheritance Community. We've been having a lot of fun. Was having some chat today in that community about how to name a trust when you're opening a trust account, particularly if that trust had been restated once or more than once. So anyway, let me head over to the chat and let's see what's going on here. Got a lot of hellos. Dan, Larry, Susie, May. We've got Ray and Bradley and Lacey and Lynn. And man, this is the most hellos I've ever seen from the beginning. All right, Larry, I do a lot of gifting with my family and would like to do more. Problem is, so much is tied up in, okay. Larry, so many times we just, great minds think alike. So much is tied up in tax deferred accounts. The taxes would be prohibitive. I use RM. Larry, it's funny. That's exactly what I was talking about. So it's such a good point. Saudi, good evening. We got some skulls there. That's either scary or funny. I'm not sure. See you always. Great. You're welcome. See you. You guys are making my day. All I'm trying to do here is get more people to think about this stuff a little bit more, make some informed decisions. Hi, DB, with the hey emoji, digging that too. How's Medicaid going to look at gifting the kids $13,000 max each year, or $18,000 max? All right. Yeah. So let's touch on that. When someone applies, goes into a nursing home and they apply for Medicaid, probably the bigger obstacle, who is that? Jerry, is are they going to meet the assets of their asset test? Because if they just gave away $18,000 to people each year They probably still have assets in their name. So they may very well be more than the $2,000 countable resource limit that most states have. But let's say, for example, an individual did give a bunch of people $18,000 over many years, and now they have less than $2,000, and they go into a nursing home and they apply for Medicaid. Well, if they made any gifts within the previous 5 years, I think it's 3 years if you're in California, you're not going to be eligible for Medicaid. So people often confuse this $18,000 present interest annual exclusion gift, which is pure tax law. It's pure, how much can I get out of my estate under the gift and estate tax rules. People often confuse that present interest annual exclusion rule of $18,000 with the long-term care Medicaid eligibility rules. I've done some live streams on that, but essentially, if you have assets and you want to qualify for Medicaid, and that's a whole story of whether you'd even want to qualify for Medicaid, but if you do, and if we're just purely looking at the rules, you got to get all the assets out of your name, not $18,000 at a time, but you got to get them all out of your name, and then hope 5 years passes after you get all of your assets out of your name. And yes, by getting them out of your name, you can give them to people outright. You can put them in a very particular kind of irrevocable trust where you can never get them back. And so the idea behind Medicaid planning is get it all out of your name, and then hopefully the 5-year period passes. Because if anyone applies for Medicaid, they go in a nursing home and they have no assets. If you've made some transfers within the previous 5 years, you're not going to be eligible for Medicaid for a certain period of time. So you gotta kind of forget about the whole annual exclusion gifting when it comes to Medicaid eligibility planning. Hope that helps. Mark, 5 million. I don't even have 100,000. I'm 60 years old. That's okay. Hey, that's okay. And I know I use numbers, and I know my numbers offend some people, or they don't apply to certain people. Great that you have 100,000. Don't even have $100,000. Well, great that you have maybe somewhere that's approaching $100,000. Better than nothing. So that doesn't mean you can't have a fantastic life. Johnny 5, can grandpa give his son $18,000 and another $18,000 to grandchildren who is 10 years old? The grandchild can't really spend the money as they wish. So with the IRS view that you can give $18,000 to your son, and you can give $18,000 to your grandchild. Now, when you say you're giving $18,000 to your 10-year-old grandchild, are you really giving that money to your son? Or are you really giving it to your grandchild? Are you putting it in a Uniform Gifts to Minors Act or Uniform Transfers to Minors Act account for the grandson? Are you putting it in a 529 plan for the grandson? Are you putting it in a trust account for the grandson? Or are you putting it into some other kind of minors account for the grandson? So yeah, you can do that. You can give $18,000 to your child. You can give $18,000 to an infant as long as you give it the right way. Yes, that minor grandchild donee is not going to really be able to control it until they're adults, but that doesn't mean you can't make the gift. So very good question, Johnny 5. Crummy Trust is for the kids. Yep. I didn't talk too much about Crummy. I should have. I'm glad you brought that up, Susie. Really important. So let's say you want to give $18,000 to all your grandkids, for example, but they're young. Let's just keep the minor part out of it now. And let's say you have a 19-year-old grandchild, but you want to give them $18,000, but you don't want to, dump it in their lap because they're going to go buy whatever the hot vehicle is of the day. I don't even know what that is. If any of you know what 18-year-olds like to drive these days, put it in there. Mustang? I don't know. Corvette was back in the day. Okay, so what many people do is they set up what's called a Crummy Trust, Crummey. Terrible name, named after a court case with the IRS, and the person who did the gifting, their last name happened to be Crummy. So now we call it a Crummy Trust. For you to take advantage of this $18,000 present interest annual exclusion by making a gift to a 19-year-old in a trust, maybe you have a 19-year-old grandchild and you say, I'm going to set up a trust for that 19-year-old grandchild for my grandson. I'm going to name my son as the trustee of that trust so my 19-year-old grandson can't blow it. Well, in order to take advantage of the $18,000 present interest annual exclusion, you have to give that 19-year-old grandson, when you put that money in the trust, you have to give them a present interest in the money. And typically it's for 30 days. Basically, you have to go to that grandson and say, hey, grandson, I'm putting $18,000 in a trust for you. For the next 30 days, you have the right to exercise your crummy rights. You can take the money out of the trust and it's yours. And if you don't exercise that crummy right within the next 30 days, then the money's going to stay in the trust and it's going to be subject, to all the trust terms. You'll get it when you're 40 or 50 or 60, or when your dad, as the trustee, says you can have it. Depends on the trust terms. And so, quite frankly, many of those grandchildren realize that they'll never get a gift again if they exercise their crummy rights, so they don't. But it's this $18,000 rule. It's called the present interest annual exclusion. So if you make a gift in trust for someone, you have to give them a present interest in the money. And then if they don't exercise their crummy right or exercise their present interest right, then it stays in the trust pursuant to the trust terms. Because you don't want to violate that rule and put it in trust for them. Don't give them their crummy rights. Then you made a gift of a future interest, which doesn't qualify for the $18,000 present interest annual exclusion. Maybe more on that later. I feel like I'm starting to get over some people's heads. Mark, you guys worrying about money can gift me instead. Okay, so Mark is applying as a potential donee. So if you want to do some gifting, Mark is volunteering, and it probably won't be any problem getting other volunteers, but Mark is first in line. And Susie says, nice try, Mark. And hi. Oh, and your punctuality, we got to work on that. Love the emojis, and the emoji will make up for being late. That's okay. Mark, having money is pain. Always worrying about tax. Who gets how much? Well, consider getting rid of you. All right. So Ann says, great idea, Mark. Mark says, thanks, Ann. Okay. Never had a spouse or kids, but watching anyways. Good, DB. Yep. Learning is, and knowledge is power. Mark, well, surviving spouse can meet a con man and lose all the wealth. I've seen it too many times. Maybe that's a reason for leaving assets to the children when the first spouse dies. Of course, there's an in-betweener there. It's not just leave it to the kids or leave it to the spouse. You can leave it in a trust for your spouse. Maybe your spouse will be the trustee. Maybe your spouse will be a co-trustee. Maybe your spouse will not be a trustee or co-trustee at all. But then you're leaving assets to a trust for your spouse, and if your spouse needs it, distributions can be made for your spouse. But when your spouse dies, those assets revert back to your children, your heirs. That's that kind of in-betweener between just leaving assets to kids and leaving assets to a spouse. That in-betweener is leaving assets in trust for a spouse, but protecting the future inheritance rights of your children. Good question there. All right, Mark, I recently met an elderly man, dementia. Yeah, it's terrible. And so married couples need to take all that into consideration when they're figuring out how to do things. Pamela, what can you do to avoid estate taxes if your parents left their properties in an S corp? No step up applies. The basis is very low and taxes are huge. But if the parents leave the S corp stock and the S corp owns, has assets in it that have a low basis, but there's still the step up so long as the S corp stock is left as an inheritance when the parents pass away. Larry, one thing I did 2 years ago was build a very large shop at my son's house. Got a share secured loan from credit union. Awesome. There you go. Fantastic. So got a really low percentage loan, 1.9. Well, you got that loan at all-time low. Fantastic. And then you're using the RMDs, which you just get annually, to pay off to make those payments. So sounds like that worked out great. Genius move. Okay, and got good and good. All right. Super. Check the channel page. I've got several live streams scheduled for the coming days. Got some good topics. Feel free if you want to become a member of our community and kind of take these conversations a little further. Feel free to check in the description. There's the sign up on our Impactful Inheritance community. Yes, there's an expense for being a member of the community, but your first 30 days are free, so you can check it out. We'll see you next time. Y'all have a good night.